Welcome to Legal Bachit. In today's video, we are delving into a critical part of the Insolvency and Bankruptcy Code Section 13. Introduction to Section 13. Section 13 is a cornerstone in the process of corporate insolvency resolution. It is activated immediately after an insolvency application is admitted under Sections 7, 9, or 10 of the Insolvency and Bankruptcy Code. This crucial section mandates three key steps: declaring a moratorium, making a public announcement about the insolvency process, and appointing an interim resolution professional. The declaration of a moratorium, as further detailed in Section 14, is a critical measure. It halts all legal proceedings against the company, providing a necessary pause for restructuring efforts. The public announcement serves to ensure transparency, inviting claimants to come forward with their claims. Concurrently, the interim resolution professional assumes control of the company's operations, steering it through the insolvency resolution process. For stakeholders, including creditors, employees, and investors, understanding Section 13 is vital. It sets the stage for how insolvency resolutions are conducted, significantly impacting their rights and interests. With this overview in place, let's now explore the nuances of each clause in Section 13 and their real-world applications. Having introduced the overarching significance of Section 13 in the Insolvency and Bankruptcy Code, let's now dive deeper into its specific provisions. This next segment will guide us through the nuances of subsection 1 and 2, unraveling their critical roles in the insolvency process. We will explore the declaration of a moratorium, the intricacies of the public announcement, and the vital function of the interim resolution professional. Understanding these subsections is key to comprehending the full scope and impact of Section 13 on corporate insolvency proceedings. Overview of Section 13 and its subsections. Subsection 1. Subsection 1 of Section 13 comes into play immediately after an insolvency application is accepted under Sections 7, 9, or 10. This is a critical juncture in the insolvency resolution process, setting into motion several key actions. Moratorium declaration. The first action is the declaration of a moratorium. What is a moratorium? It's essentially a temporary freeze on all legal proceedings and actions against the debtor company. This period allows the company to reorganize its affairs without external pressures, a crucial step for a fair and effective resolution process. Public announcement and claims. Next, a public announcement is made about the initiation of the insolvency process. This announcement is vital for transparency and invites creditors to submit their claims. It ensures that all interested parties are aware of the insolvency proceedings and have an opportunity to present their claims within a specified deadline. Subsection 2. Moving on to subsection 2. This part of Section 13 emphasizes the timing of the public announcement. It stipulates that the announcement must be made immediately after the appointment of the interim resolution professional. This timing is crucial to ensure the process's efficiency and transparency, giving all stakeholders prompt notice of the insolvency proceedings. With a clearer understanding of Section 13's key components now established, let's shift our focus to the real-world impact of these provisions. In the upcoming segment, we will delve into the case law highlights, where pivotal court decisions have shaped the interpretation and application of Section 13. These cases not only illustrate the legal principles in action but also provide valuable insights into the practicalities of the insolvency resolution process. Join me as we explore these landmark judgments and their significance in the realm of corporate insolvency law. Innovative Industries Limited versus ICICI Bank and ANR, 2017. This case addressed the interplay between the Insolvency and Bankruptcy Code and state law, clarifying the supremacy of the code. It set a precedent for the application of the moratorium provisions and reinforced the jurisdiction of the NCLT in insolvency matters. ArcelorMittal India Private Limited vs Satish Kumar Gupta and Oz, 2018. This case dealt with the eligibility of resolution applicants, outlining criteria for their participation in the resolution process. It highlighted the importance of due diligence during the moratorium period and the role of resolution professionals in scrutinizing resolution plans. Swiss Ribbons Private Limited and ANR vs Union of India and Oz, 2019. This case was a constitutional challenge to various provisions of the Insolvency and Bankruptcy Code, including those concerning the resolution professional. The judgment validated the code's provisions, affirming the role and actions of resolution professionals during the moratorium period under Section 13. Having explored how landmark judgments have influenced the interpretation of Section 13, we now turn to a segment where your queries take center stage. In the viewer Q&A, we'll address the most common and pressing questions you have about Section 13. This is an opportunity to clarify doubts and expand our understanding of this crucial legal provision. Let's delve into your questions and unpack the complexities of Section 13 with focused, informative responses. What happens during the moratorium period under Section 13? During the moratorium period, all legal actions against the debtor company are temporarily halted. This gives the company time to restructure its debts without the pressure of legal proceedings or asset seizures. How is the public announcement under Section 13 made, and why is it important? The public announcement is made immediately after the appointment of the interim resolution professional. It's crucial for transparency, as it informs creditors and other stakeholders about the insolvency proceedings and invites them to submit their claims. What is the role of the interim resolution professional appointed under Section 13? The interim resolution professional takes over the management of the debtor company during the insolvency resolution process. They are responsible for collecting creditor claims, maintaining the company's operations, and overseeing the development of a resolution plan. Conclusion. In today's video, we've navigated through the intricate details of Section 13, exploring its pivotal role in the insolvency resolution process. We began by understanding the crucial steps initiated post-admission of insolvency applications, including the declaration of a moratorium, the importance of public announcements, and the appointment of an interim resolution professional. Key case laws such as Innovative Industries vs. ICICI Bank and Swiss Ribbons Private Limited vs. Union of India highlighted the legal interpretations and applications of this section. We also addressed your questions, shedding light on practical aspects of Section 13. Remember, your engagement helps us grow and continue providing insightful legal content. So, don't forget to like, share, and subscribe for more in-depth legal analyses. Stay tuned for our upcoming videos, where we'll delve into other critical sections of the Insolvency and Bankruptcy Code, demystifying complex legal concepts. Thank you for watching and keep the conversation going in the comments below.